It's a good morning to you. Welcome to Asake Online. My name is Zenzere Ndebele, and this is the Breakfast Club. There are so many topical issues that we always talk about in this program, but also in Zimbabwe in general. This country, if you're not talking about an amended law, if you're not talking about an SI, you're talking about a policy that has been introduced or a statement by a minister, there is always something that is not developmental, that doesn't enhance our lives, but that is trying to take away what we already have. We live in a country where there are limited freedoms. But these limited freedoms that we have, they keep on taking bit by bit, something that we always argue about. And we have no time to talk about development. We have no time to talk about, how do we better our lives? How do we, close the potholes that are all over town? So today in our program, we'll be talking about another problem, another law that is proposed, and that is the proposed PVO Act Amendment Bill, or the Voluntary Organizations Amendment Bill, that seeks to change the way NGOs and non-governmental organizations are working. And there have been a lot of talk about how this proposed law is going to affect the operations of NGOs, but also affect you and me. It would affect employment. It would affect a lot of things. It would affect beneficiaries. So many people in Zimbabwe get something from non-governmental organizations. And to help me break down this amendment bill or the proposed law, I'll be talking to a human rights lawyer, Nosimilo Chanayiwa, to try and make us understand this law. Welcome to the program.
Thank you.
Maybe my first question to you will be, what is this amendment bill?
So the amendment bill, a bill is proposed law, which is being put out to people to debate on it until it then follows all the processes and then becomes law. So the amendment bill, the Private Voluntary Organizations Bill, seeks to amend what's already there, the Private Voluntary Organizations Act. So it's really an amendment, and most of the provisions are more of an addition to what we have, and maybe to tinker a few provisions that are there in the current act.
Who is likely to be affected by this proposed amendments?
The way the bill is crafted, the provisions are far-reaching. They naturally would affect the non-profit sector. Currently, in our Private Voluntary Organizations Act, the application of the Act only goes as far as only the organizations that have registered in terms of the Act. But the bill seeks now to cover all organizations that are in the non-profit sector. In that regard, the bill provides that the registrar of PVOs will issue a declaration or a declarator to an organization that is not registered as a private voluntary organization, but one that provides charitable services and one that receives funding from outside the country. So that is the criteria. It means that if you are a charitable organization and you're receiving funding from outside the country, then and you're issued with that declarator, then you will be subject to the application of the bill or the act if it subsequently becomes the law.
So at face value, the way you say it sounds scary, because the non-profit sector includes trusts, I guess, which includes schools, which includes burial societies, which includes churches, it includes family trusts, and all. Is it scary as you just put it?
It is scary. I would think that it is. I think what makes it even scarier is that the bill provides that once you have been issued with that declarator by the registrar, you should register as a PVO within 30 days. Failure to do that, then the operations would be illegal. But the bill does not have corresponding obligation upon the registrar to actually register the organization. I say that is scary because over the years, organizations have actually tried to register as PVOs, and they failed because of the cumbersome process. Some have not received a response for years, and then they've then opted to register as trusts. So now it means that even if an organization does put in the effort to comply with the provisions or that declarator when it comes, they might not be registered within 30 days because the bill does not place an obligation on the registrar. So it means automatically their operations become illegal after 30 days. And that is scary because then it creates that uncertainty whether or not organizations will be able to continue to operate. So again, it is scary because if then organizations are unable to operate, organizations in Zimbabwe provide all sorts of services which are not provided for by anyone. So it's not just the organizations that will suffer. It's millions of people who receive services. Organizations provide from legal services, psychosocial services. There are media organizations that provide information that you cannot get anywhere else. Medical services, humanitarian services, you name it. So it goes to a whole lot of other beneficiaries who may not be able to access these services if the bill comes through and these organizations are unable to register beyond the 30 days.
But what I also find unrealistic is that I know organizations that have spent up to 2 years waiting to be registered as a PVO organization, and they failed. And the PVO board takes its time, and they sit once a month to consider these applications. So we now want, or the government is now proposing, that every organization that is registered as a trust and everything stampede to register within 30 days. Is that realistic?
Well, it doesn't sound so, but I would think that at least from my understanding of the provisions, that you are expected to register when you have been issued with the declaration. And either you register or you also declare that you will no longer be receiving funds from outside the country, then you'll be allowed to operate. But for our current setup where organizations get funding from outside the country, we know that barely any will be able to make that declaration. So I don't know if those declarations will be issued all at once or they'll be staggered. I am not sure. The bill is not clear in that regard.
So that means in this regard, they offer, let's say it's Zimbabwe Lawyers for Human Rights, they offer you, they write to you and say, with this letter, we are compelling you to be registered under the PVO Act.
Yes.
So if I have not been written to, I can operate as I want.
That is my understanding, or at least that is the interpretation that we have given to it as Zimbabwe Lawyers for Human Rights. It's not any clearer than that. But it seems to suggest that either that or the minister will designate an organization as high risk. Once you have been designated as high risk, then you'll be compelled to register within the 30 days.
It seems like it's targeted, that's what worries me. But also when I was looking at this bill, there are also proposals that once, you have not registered, the minister can, or even when you are registered, and the minister is not happy with what is going on, he can fire the board that is there and appoint a caretaker board that will take care of the operations.
Mm-hmm.
Meaning they will also be in charge of the finances of that organization, and they can receive salaries from that organization.
Certainly. That provision, and I think most of the provisions that relate to the minister are concerning because the minister has excessive powers. So like you say, the bill provides that the minister can suspend the entire executive committee and then put on provisional trustees. What is concerning about that is the procedure even, because it's not set out. It's purely at the discretion of the minister. And the bill says that the minister can do that based on information that he receives. It doesn't say what kind of information from where, how it's verified or investigated. So once the minister receives information which in terms of the bill shows that the organization is not complying with its constitution, or there's maladministration, or it's said that there are illegal activities going on, or it's in the public interest, then the minister can suspend the entire board. and then put on his own people who are going to be paid by the organization at a fee that is determined by him. And those people can make...
so the minister determines the fee?
Yes.
On the money that does, on funds that don't belong to him?
Yes. So in terms of the bill, once that the provisional trustees take over the organization, they have the same powers as the people that have been suspended. They have expansive powers, including that they can actually acquire assets or dispose of assets. They can make any decision. And I think what is even more worrisome is that whatever decisions that they make, what they're supposed to do is supposed to be up to a period of 60 days. Whatever decisions that they make in that period, they remain valid, even if later on the court decides that the decision of the minister was wrong. Then when the executive committee comes back, they take over from there.
If there's anything to take over.
If there's anything to take over. I think also what is concerning about the bill is that it provides that the decision of the minister should be confirmed by the High Court. But then the minister still goes ahead and executes that decision, pending whatever determination of the High Court. And so it means that if it's a wrong decision, even if the High Court eventually says that that decision by the minister was wrong, still the decisions that were made during that period remain valid and binding to the organization, unless if it can be proven that they were done in bad faith, which is quite a stretch.
Yeah, you know, I see a situation where the new board comes and makes a resolution to dissolve the organization and distributes to assets to wherever, and it's done. By the time the High Court says it was a wrong decision, the organization no longer exists.
That's a real possibility.
So the other question, or the other thing that we've heard, is that there is money laundering, and this. So we are trying to make sure that there's no money laundering. Do you think the bill is justified?
So when the bill came out, the justification for the bill was that we need to comply with the Financial Action Task Force recommendations. So the Financial Action Task Force is an international body that sets standards and policies relating to money laundering and financing of terrorism. Zimbabwe is a member of that body, and that body reviews countries occasionally to ensure that there's compliance with the recommendations. Sorry to go roundabout. I just want to put a bit of context.
Yeah, it's quite important.
Yes. So when Zimbabwe was reviewed, there are a number of recommendations that were made, and amongst them was that Zimbabwe is, well, there are, I think, about 3 that were said not to have complied fully with. And amongst those was recommendation number 8, which has brought us to this bill. So that recommendation says that governments need to assess the non-profit sector for vulnerability of money laundering and financing of terrorism. And after that assessment, then put in measures to address the vulnerability. So government has then now said that they're addressing that recommendation by putting in place this bill. So the bill in its current context, it does not address those recommendations, because for starters, the recommendation says that there should be an assessment. And if you look at the reports from the Financial Action Task Force, it says that when there's an assessment, there has to be a methodology. There have to be indicators, and the sector that's affected should be involved. Right now, the bill does not even talk about that assessment. It says that the minister will designate, but it's purely discretionary. It doesn't show how he will designate. At least if that section had set out how, you know, following those provisions by FATF, then it would have assisted. So the way it is, the way the bill is crafted, it's not clear how it's going to address money laundering or financing of terrorism.
You know, what I find interesting as well is that in Zimbabwe, it's easy to bring in money, but you can't transfer money outside the country. You know, as an individual, an organization, I can't go there and wire $1,000 to the US or to South Africa without the RBZ approving the transaction, and that takes years. So, but we know, I mean, gold dealing is going every. So, is the NGO sector really a threat when it comes to money laundering?
I think the response for that, we can only get it once an assessment has been done, because now there has been no assessment, and therefore the justification then for this bill is a bit limited. But the Financial Action Task Force itself has done an assessment generally, and the indication is that the sector is not so vulnerable. But even within the sector, it has shown that the vulnerability levels are different, because the nonprofit sector is broad. There are organizations that work in humanitarian activities, that do expression work, human rights. These are the organizations that do human rights work and governance. The levels of vulnerability are different. So it would be important for our government to do the assessment and then put in place measures that would then deal with the risk that has been identified. And the measures, even within the same sector, they do not have to cut across the board. They have to be consistent with the level of risk.
Should people who are registered as trusts and non-profit sector be worried about these people?
I think that they should, because there's now uncertainty. There's uncertainty, for starters, whether they'll receive that declaration or they'll be declared as high risk by the minister. And if they are declared, and even if they try to comply with the requirements within those 30 days, if they'll actually be registered. So that is concerning. It creates a lot of uncertainty. And they should be concerned because there are also other provisions which makes operations very uncertain. For example, the register has excessive powers in terms of the bill. There are provisions in the bill that say that when an organization makes material changes, they have to notify the register. And unfortunately, it's not just a notification so that the register keeps it in the record. The registrar has powers to actually reverse whatever material changes that they've made, or reject them, or deregister the organization. And the material changes in the bill would include changes to the constitution or changes to personnel. These are changes that, in the lifetime of an organization are inevitable. So it means that the registrar actually has more control of organizations than we think. And if they are unhappy with any of those changes, they can actually deregister an organization. So that is concerning.
Yeah, it's I'm not sure where it actually leaves NGOs and non-profits, because it also, we're likely to see if organizations are deregistered or banned or whatever, unemployment, because this sector employs a lot of people. So there's also that risk of unemployment, loss of funding, and probably the organizations themselves, being closed or dissolved and all those kind of. But what can be done at this stage to try and reason with the government?
I think at this stage, what can be done is to disseminate information in a very simplified manner about the bill to the affected stakeholders, so that, for starters, they understand the implications of the bill. And when Parliament goes out for the public outreaches, people are able to express themselves and articulate what needs to be changed, or if it should be there to start with. But also, I think there's need for advocacy with the relevant offices, the different layers of government, to say that I think there's a common understanding that Zimbabwe is a member of the international community. We have to comply with these international recommendations, but there is a way to comply with them without stifling or crippling the sector. And it doesn't have to be a bill, especially the way it is. Let's start with, for example, assessment of the sector, including everyone who's affected in the sector, and then identify measures. There are other measures that we can use. For starters, we already have laws that deal with money laundering and financing of terrorism. there's no reason why those laws seem not to be applied to the sector. They already apply to everyone else. And, there are other ways to control this issue of money laundering within the sector. The sector can regulate itself. Maybe the sector has also left it a little too long, but the sector can regulate itself. We have doctors have their own regulatory body. Lawyers have their own regulatory body that's made up of lawyers. The sector can have its own regulatory body that ensures that its own members comply with international standards of money laundering and financing. Everything else, that we set up proper structures and so on, we comply with taxes, that can be done, and it will be less burdensome for government.
So let's say all this fails and the law is passed. What remedies are there? Can people challenge that in court, or it's done, you then have to comply?
So if all fails and it becomes law, then it certainly can be challenged in court for a violation of certain rights, the rights to freedom of expression, freedom of association, because there are some provisions where you see that organizations are being targeted because they receive funding. So once you're associated with a foreign funder, then that is the level of targeting. It can be challenged, but pending the challenge of the court, then organizations will have to comply with the provisions.
Let me put you on the spot and say, as a human rights lawyer yourself, what's your take? Where do you think the dice will roll?
You've really put me on this on the spot. You mean in terms of whether it will become law or not?
Yeah.
My personal feeling is that it shouldn't be law. That's my personal feeling, because as a human rights lawyer, I work with indigent people who cannot afford services. I work with people who need a whole lot of services other than the services that I can provide for them, psychosocial support and so on. And in my years of working, the only people who've been able to provide those services are NGOs. So I would wish and hope that the bill doesn't come into play, because those sort of beneficiaries, I don't even know where they'll get relief, to be honest. And the level of violations of human rights continues unabated, regardless of the provision of those services. So I can't imagine what things would look like if organizations cannot provide those services for those people, the people in places that you've never heard of in Pinga, that will be seeing a lawyer for the first time and they marvel. So I can't imagine a doctor or a lawyer being able to go to those places outside the framework of non-profit organizations.
Okay, I think I would like to thank you for this discussion. I mean, I for one who always gets arrested once in a while. I know the pressure of being arrested, but I also know the relief of knowing that a lawyer is coming and I'm not paying for the lawyer, because I wouldn't afford the rates of a lawyer. Lawyers are very expensive. And having been represented so much time, and these cases take 4 months, 5 months, and not pay anything, I know what it means to get legal representation from human rights organizations that are registered as trusts. But also working with communities and appealing to people every day, for people who want an operation, who want food, who want birth certificates, and all the needs that people have in our communities, and getting these things from NGOs. Poles drilled, even in town here in Bulawayo, there are communities where NGOs have come up with, Jojo tanks or water tanks, because there is no water in the communities. But there are people who are benefiting from vegetable gardens, or benefiting from imbuzi, inkomo, and all these kind of things, medical supplies. So we depend on NGOs. But knowing the number of families that are putting bread on the table because their family members are employed in the NGO sector makes me wonder why The people who are calling themselves the Second Republic are going to be worse than the First Republic. We all thought that Robert Mugabe was bad, and I don't think we want to see the worst. So I'm really appealing to the political powers who have claimed that they were there to make us better, they were there to do better than Mugabe, that they shouldn't make us remember or say, but Mugabe wayengcono, because this is exactly what they are doing. I mean, you are taking us back to Egypt, and we regret why you even came on the 17th of November, because you are performing worse than Robert Mugabe. My name is Zenzele Ndebele. Till we meet again in other programs, have a good day.